Good evening, everybody. Kernan Manion here, and I am joined by Michael Langan. Hello, Michael.
Hello, Kernan.
Hey, you can hear me okay? I want to make
Okay.
sure that all of our connections are open here. You can hear me okay?
Can hear you okay.
All right, very good. We are going to allow some time here to allow our participants to assemble, but we have quite a few gathered so far. Let's just get our bearings here. Welcome everyone as you continue to sign in. We have a great attendance registered for tonight, and we have a lot of material to cover. So while people are signing in, I just wanted to remind you of some of the basics here on the Zoom panel here. We do have a chat box at the bottom of your screen, and I want to remind you of that because even though we're not going to have Q&A tonight, we are going to be watching the comments as they come in, especially in terms of feedback with regard to our presentation, questions that you may have that we can later answer in a post. So we are looking forward to having a great presentation tonight. We have a tremendous amount to cover here. You'll note on your screen also on the Zoom screen in the upper right-hand corner, you'll see on your browser screen in Zoom, you have the opportunity for a speaker view versus a gallery view. So if you click that, that allows you to see either one speaker, the one who's speaking right now, and you'll see me kind of outlined in lime, yellow, green, or you can have the gallery view in which you see both of us simultaneously. Now, when we switch over to the slide presentation, we're going to have the primary screen on the slide presentation. I see someone doing a test on the chat. Thank you so much. And yes, indeed, we are watching the chat here, so thank you. All right, let's go ahead and get started here. I'm going to share our opening slide here, Michael, and then we're going to come back to a full screen and talk a little bit about our presentation, okay? So bear with me here, and off we go. So welcome everyone. I hope everyone can see the main screen here, the title screen, the Perilous Physician Licensing Landscape. I'm Kernan Manion, and Michael Langan is joining me from Maine.
Boston, actually.
Where's that? Oh, that's right, you're in Boston now. That's right, exactly. So, you know, one of the things that we're predominantly focusing on here is the concern that Michael and I and others have had about what's going on to physicians around the country with regard to disciplinary activities being undertaken by boards, PHPs, and other entities. And what we found over this process is that healthcare providers are being pulled into career-threatening administrative legal challenges. And these legal challenges clearly have major import in their lives. So let's say a little bit about who we are and how we got involved. Michael, if you would go ahead and introduce yourself and say how you got involved in this whole process.
I'm Michael Langan, and I was introduced to the Physicians Health Programs I had read about in the Medical Society newsletter. I got through medical school and residency without getting chickenpox. It was before the vaccine, and I never had chickenpox as a child, and I knew I was susceptible to it, and I got it from somebody with shingles. So I was taking a medication only at night, and I had read about the Physicians Health Program and went to them for advice on tapering off of it. Before I knew it, I was thrust into a system where I had to pay $5,000 cash for an evaluation, $80,000 for assessment and treatment, and before graduating a year and a half, I was given a test that said I was an alcoholic. And since that time, I've been trying to find out how exactly this has occurred, what's going on, and I've been researching it for the past 7 years. It took about 3 years to figure out what exactly was going on. But once you see it, you can't unsee it. And since that time,
Great.
I've been in touch with hundreds of other physicians, medical students, residents, interns, who've gone different circumstances, but exactly the same.
And it's all fair to say that other healthcare providers as well. Dentists.
Other health nurse. It depends on the state.
Yes. Yeah.
But the majority of them, from what I'm hearing, there are the same patterns involved.
Yeah.
They're getting outside evaluations, and for example, in my case, never a patient complaint, never a malpractice, even threatened. In 15 years at Massachusetts General Hospital and 19 years at Harvard Medical School, never a complaint. And it's the same thing I'm hearing over and over again. The patterns are clear.
Great. Well, thank you. And so I'm Kernan Manion, and I also, like Michael, have been through a perilous journey with regard to the entire administrative system, the medical board system, the PHP system. I did not get subjected to peer review in the traditional sense, but because of my journey, likewise, and I'm sure most people who are attending tonight, what happens is that you start searching and you're saying, like, how do I make sense of this? And you start connecting with people. And so that's how Michael and I came to get to know each other, was actually through his blog, disruptedphysician.com. And Michael has been running that blog, now for how many years, Michael?
4 years now.
Oh, 4 years. Wow. Okay. So Michael's blog, if you have not checked it out yet, is disruptedphysician.com. And mine is my coaching blog is kernanmanionmd.com. And I began recently writing some blog pieces and bringing in some articles on a new website, physicianrights.wordpress.com. So you'll be getting all of this information on a handout subsequent to our presentation tonight. So Michael and I have spoken with literally hundreds of docs around the country and other healthcare providers as well, dentists, veterinarians, physician assistants, nurses, and pharmacists. And we're hearing some remarkably similar and unsettling stories that are at times really quite horrifying. So we've put together a body of information from those many conversations, those many dialogues that we've had helping to advise people, and we've also brought in our own experience and, needless to say, extensive study of these issues, of case decisions that have been in the state and federal courts. And as I said here, we're from the School of Hard Knocks. We've been through it. We've walked the territory. So at our core, we're really about physician advocacy. We're about due process and fairness. We're about transparency, about having state agencies accountable. And we are also about patient protection, because when a physician's career gets interrupted, her entire panel of patients is now interrupted. So our purpose tonight, in a very concise way, is to provide a broad overview of the landscape of medical discipline, of physician licensing in this administrative arena, to empower you. Because if you're anything like us, you're groping in the dark, or have been groping in the dark about, well, what do we do and how do we make sense of this thing? We want to help validate the reality that, in fact, there are some very challenging things ahead. We want to offer our perspective, our guidance, and our support. Because one of the things that happens is that you face this battle alone and you feel like, oh my gosh, this is overwhelming. And Michael and I and a host of other people have been gathering, and we really want to work to change the system toward the better. We want to confront these abuses as we see them. So initially, our focus was on the PHP issue, because we both got roped into this PHP. PHP, for those who don't know, stands for Physicians Health Program. And so initially we thought, okay, it's the Physician Health Program thing that we're focusing on. But then we saw that there was a relationship to physician health programs and boards. It was very difficult to tease these two apart. And then we were hearing stories of people who were roped into the board and sent to the PHP coming via a peer review committee. They were labeled as disruptive or some other problematic behavior. And so we started seeing, oh my gosh, this is a rather complex entity. But then not only that, it also seems to be across the country. It wasn't just in our respective states. And so, oh my gosh, what we're doing is everybody is grappling, trying to make sense of this. I had physicians tell me, and Michael, I'm sure you have as well, I'd rather have 10 malpractice suits than deal with this nightmare. It's literally a Kafkaesque nightmare, right, Michael?
Exactly.
Yeah, and so as we've been following these issues, we've seen a variety of initiatives taking place, and one that just took place this past week in Louisiana, my home state, is that because of the abuses of the Louisiana State Board of Medical Examiners, a bill has been introduced into the Senate by Senator John Milkovich, and he calls it the Physician's Bill of Rights. Can you imagine? That he had the audacity that he said, look, I don't want to see this happen. He says, physicians are amongst the most thoroughly educated, highly skilled, and sacrificially selfless professionals in the world. Our doctors work long hours, grapple with the endlessly shifting regulations imposed by state government, or sometimes even fight to get paid for their work. We owe them a debt of gratitude, not a deluge of grief. And so Michael and several of us in our group have written Senator Milkovich applauding him on this initiative. This really can serve as a nationwide model of protecting physicians' rights against overreaching boards and physician health programs. Now tonight, disclaimers. First of all, what we're offering is opinion. Okay, this is not fact. We're not going to make any accusations of programs, and we're not offering legal advice. So just be clear, we're just trying to share our information with you about our journey and the journey that we've heard from others and put together the big picture. 30 minutes is not going to be enough. There's no way that we can cover this huge complexity in 30 minutes. But I want you to know that, that in addition to this webinar tonight, Michael and I spoke about offering phone consultation, a free phone consultation to every participant on this call. So we are going to offer each of you a 30-minute private, confidential phone conference with Michael and me, or one or the other of us if both of us can't be present. I want to remind you that this is an open webinar, so if you are going to use the chat box, keep in mind that there are a variety of people who are attending this, including people who may be from the respective agencies that we're speaking about. So I want to caution you about, using appropriate decorum. There's a chat box, as I said. You'll see it on your screen, and feel free to send us messages. We may not be able to attend to them right now as we're speaking because it gets so busy, but I promise you we are going to be looking at them. So initially we said, physician health programs and medical boards, and then we said peer review, and then we started to discover this concept of sham peer review, which the Academy of American Physicians and Surgeons and Dr. Lawrence Huntoon and Dr. Jane Orient have really taken on as sort of their central work. And we started to wonder, is this a racket? Are people getting pulled into a racket? And fortunately, there has been a real resurgence, or surgence, I should say, of concern about the addictions treatment racket. So Michael is going to be talking a little bit about this here. So I want to pose a question to you here. The administrative licensing disciplinary system, is it rigged against you, or do you find it to be a fair entity? Let me see if I can bring up this poll here. So here is the poll, okay? Do you feel that the medical disciplinary process is fair to physicians? If you would take a moment to answer yes or no. And we'll just pause here. We have about 25 attendees tonight. I'm really delighted to see that. So let's just take just a few more moments, because we have certainly heard amongst the people that we've spoken with that they don't feel that they have been treated fairly. So just 5 more seconds here if you want to get your last votes in here. So here's what we have, that there's a significant opinion here. Can you all see the screen? Michael, can you see the results there? Okay, great. And what we find here is that the general sentiment amongst our audience, admittedly a self-selected group, is that there is not fairness. 100% of our participants are saying, no, I don't feel this is a really fair process here. So Michael, I'd like to hear from you let's talk a little bit about the PHP system, what it is, and how does somebody get into it?
Well, first of all, it's important to understand that physicians' health programs, or PHPs, are precisely what employee assistance programs are, or EAPs. Now, employee assistance programs started in the early 1900s as industrial alcohol programs, and they were a resource for employees who had problems with alcohol, and they could report to this. Usually work contained in the workplace, such as Kodak and other places. They had these employee assistance programs. You could go to them, get help. And the idea was to get help prior to being involved in a workplace accident or something that could cause a damage either to the employee or to the company.
So they were initially well motivated, you're saying?
Yes, and physicians' health programs, they did not come into place until the 1970s, and this was after the Journal of American Medical Association came out with the article "The Sick Physician," which essentially acknowledged that doctors had substance abuse problems and psychiatric issues just like the rest of the populations. So these physicians' health programs, usually funded by medical societies, started popping up across the country.
Right.
They were staffed by volunteer physicians who were there to just to help colleagues, protect the public, and assist a colleague who the only route at that time was either disciplinary action by the state medical board.
So what in the interest of time, I want to focus, that sounds very benevolent, how they get derailed.
Well, here's the difference. The difference is any other occupation, if you look at it, with an EAP from the early 1900s, has a union or some other organization who is looking out for the best interests of the employee. Now, as physicians, we didn't have that.
Right.
So these benevolent organizations were in each state by 1980, in every state. And as I said, they were funded by the medical society with volunteer physicians. There were no outside interests.
Right.
There was no oversight, no regulation, and no accountability. And accountability, that requires the provision of information and also a justification for one's actions.
Right.
So to this day, physicians' health programs do not have any oversight, regulation, or meaningful accountability.
So it creates a real problem here. So some of the things that we've seen here with regard to what's happened with physician health programs, how they veered off course, their derangements. What we've seen is that the stories we've heard is that people are being sent to a PHP and false diagnoses are being made. And even there seems to be a possibility that diagnosis rigging is taking place and prearrangements with the facilities that they refer to. We're hearing reports of denial of access to one's PHP assessment record, that one undergoes an evaluation and then they can't even get hold of their record. We're finding that PHPs are funneling people into what's called "quote unquote" preferred programs, and there's a concern about that. And then we find that there's been a false assessment of impairment, that the person really isn't impaired, but a false evaluation of the severity of impairment is being made. Additionally, we're finding that PHPs are preventing the presentation of evidence to the contrary, so that even though one has one or more diagnostic consultations that say, no, the PHP diagnosis was wrong, they're refusing to incorporate that. We're finding that PHPs are refusing to honor a grievance process. We're finding that they're subjecting people to extensive on-site monitoring that is humiliating and costly and in 5 years in length. And even worse, we're finding that even when you are able to document with others the system has denied you of your rights, there's no oversight, there's no body to appeal to say that the system is broken. So the themes that we're seeing, Michael, are that PHPs seem to have stolen a psychiatric identity. They seem to be operating as though they're legitimate mental health entities, but what's happening is that they're not licensed to do that. They're making diagnoses. Some of them seem to be, and we end up with someone who has gone through what they thought was a legitimate psychiatric diagnosis process, and it wasn't. We see dishonest assessment, dishonest referral, and then dishonest sentencing recommendations. So, what are the overarching themes here, Michael, that you can see with regard to these PHP derangements?
Well, you're exactly correct, Kernan. And I have, for 3 years now, I've had a survey up on my blog. Mm-hmm. And it's a PHP survey. You can find it on there. And over the past 3 years, through the survey and talking to people individually and other communication, literally hundreds and hundreds of physicians I've talked to. And the patterns are, the circumstances may be different. What led somebody to a PHP, those circumstances are all different. What happens after they are referred to the PHP, after they present to the PHP, the mechanics are exactly the same, precisely the same. And the themes are one of complete denial of any outside evaluations, no matter how extensive the evaluation, and no matter how qualified the evaluator is. I mean, we're talking about complete disacknowledgement. I mean, it's disacknowledgement of anything. They don't even acknowledge the assessment, let alone the content of what that developed. So what we are seeing is people forced into a number of programs across the country that, as the North Carolina audit by Beth Woods, what she found is that these outside out-of-state assessment centers, that there were no qualitative or quantitative criteria for selecting them.
Yes.
Now this is like asking, and it bears noting that at the time of the North Carolina audit, the president of the director of the North Carolina PHP was the then sitting president of the Federation of State Physician Health Programs.
Yeah.
Now, he could not name any criteria for designating or approving these PHP-approved facilities other than word of mouth or reputation. Now, that's like the FDA asking, how did you approve that drug? And they said word of mouth and reputation.
Exactly right.
It's not, if it wasn't so tragic, it would be comical.
Well, no, you're exactly right, and the reason why I'm laughing about it, because it's almost a theater of the absurd, you know. And the term that you used that I really thought was classic, and that is that what's happened is that it seems that boards have decided to use PHPs as a way of bypassing the due process mechanism and then medicalizing the disciplinary process. Because as you know, when you go into a medical evaluation, there's no such thing as due process. That's a legal term. And so what happens is that you no longer have access to the usual due process mechanisms. But Michael, before you comment on that, I want to move us along here and ask, why do people continue to refer to PHPs if in fact they're such problematic entities?
Well, I mean, a simple answer is people don't know better. Most people, including most physicians, do not know what PHPs are, other than that they're referral sources for impaired physicians.
Right. So they're believing that they're actually making a useful, helpful choice.
Some are, and it all depends on how someone is referred to a PHP. Also, there's self-referral, which is a small part. People who innocently, like I did, present to the PHP for questions of. I mean, it's the classic wolves keep clothing. They're just here to help. People assume that. And I mean, what strikes me is most of us are used to an environment in which the people who we deal with inherently do the right thing. They have good heart. And you take it for granted that people are going to do the right thing. And what really bothers me is that the people who are thrust into the system, they all of a sudden realize that these are people who are not doing the right thing, and it happens step by step by step, and they're thrown into a maelstrom that they don't understand. But it's actually very traumatic for most individuals who are put into this, because the simple fact of the matter is that truth and fact do not matter here. Mm-hmm. It's a chute that you're put into, and each step is along the way is predetermined.
And that's exactly what we're going to be getting into, because we want to talk about the pathways that you can take here. In the interest of time, Michael, I'm going to speed ahead with regard to boards and peer review entities, because we want to touch on all three of these legs here. So boards, for those who don't know, boards are empowered in the state legislature, in the statutes, by what's called the Medical Practice Act. And the Medical Practice Act follows a relatively common format that has been put out by the Federation of State Medical Boards, called the Model Medical Practice Act. Now, what we've seen over our time is that medical boards seem to have partaken of mission creep. In other words, they were initially designed to ensure that the profession acts in an honorable way and people do their appropriate work. However, we found that that medical boards have overextended that reach, and we find that people are being brought in for discipline having to do with matters of their personal life that should be of no concern to practice competency. So what we've seen is that some of the patterns we're seeing with medical boards are that people are being sent on contrived anonymous complaints. We find that that they can't even get access to the nature of the complaint, and they're being hauled into an evaluation process, and they're not even being evaluated preliminarily by the board. They're being sent directly to PHP. So what we see here is a funneling here and a silencing. We're seeing that there's a bypass of administrative judicial safeguards. In other words, the administrative judicial system, which is separate from the civil judicial system, the administrative judicial system itself is being derailed by occupational licensing boards, such as those like medical boards. We're seeing the coerced consent orders and the use of unconscionable plea deals as though we're dealing with criminal proceedings. What we're seeing also with regard to medical boards is that you would think that a medical board would approach the PHP and say, well, you know, we think that you overread that diagnosis, or, you know, we have other evidence to suggest the contrary. But Michael and my and others' studies have found that medical boards invariably, from the case reports that we have, are going along with whatever diagnosis the PHP makes. And it may be, you see, that the board is actually two entities. It's a board proper, which is the appointed physicians from the governor, and it's the board legal, which is the people who are the year-round staff. And it may be that there's really not a clear communication amongst the board proper and between the board proper and the board legal, so that there may be some things that are going on that legitimate caring physicians are not even aware of with these board things. So the themes that we're seeing here with regard to boards are obfuscation of legal processes and of legal remedy. We're seeing rampant prosecutorial abuse, both investigatory as well as prosecutorial. And we're seeing just a profound bypass of due process, and as Michael said, with regard to the medicalization of the disciplinary process. So lastly, the third wing that I want to comment on is to familiarize people with the concept of peer review. Peer review basically is a quality assurance mechanism, and it was meant to allow entities to come together and talk about medical error, and to talk about how each provider is doing under a protected cover, so that it would not be discovered in a malpractice suit, and you could allow the organization to correct its ways. And so the Healthcare Quality Improvement Act, that's what HCQA is, allowed the institution of a peer review process. There are a variety of stipulations that exist for those, but it allows medical peers to assess each other for compliance with the norms of practice. However, you know, what we found with regard to looking at peer review is that the processes are often very opaque, and that physicians who are on a medical staff are not really clear about what their rights are under these peer review processes. It certainly does not appear to be a democratic process, but the process was based upon positive motivation. It was based upon a presumption of integrity. However, what we have seen is there's some derangements. And we've heard stories of basically a secret peer review committee being assembled and selectively recording those, undertaking those hearings, and the person not having any ability to defend themselves, the evidence being stacked, they can't challenge the witnesses, and they find their careers on the rails. But the first thing that happens is they lose their staff appointment. That then gets reported to the medical board. That again gets reported to the National Practitioner Data Bank. And so we find that there's another way here that physicians are not being treated fairly. So the themes that we're hearing behind these are, it's malignant staff discipline. It's a career derailment. And what it does is it then puts people into the medical licensing board PHP system. And that whole machine then does its work. And of course, one ends up getting reported to the National Practitioner Data Bank. So amongst the commonalities that we're seeing here, denial of due process, abusive policies and procedures that really weren't intended to facilitate this kind of harm. The standard operating procedure of these organizations is that they use up time. They're incredibly complex bureaucratic proceedings and delays. And all the time, these are very costly legal maneuvers, and they also eat up the statute of limitations clock. There's no recourse for physicians to call to a higher authority and say, whoa, wait a minute, look at this whole process is deranged, because guess what? There's no government oversight. We don't know whether that's accidental or intentional. And further, these agencies operate with no liability whatsoever, and as designated state agencies, most are immune to suit under the principle of sovereign immunity. So the bottom line here is that once you're pulled into this process, you're in a weakened position from the outset. You're guilty. You cannot prove you're innocent. You cannot protest the process. You will suffer the consequences, and you end up being pulled into a process that you call dehumanization and delegitimization. Can you comment on that, Michael? Dehumanization.
Yeah, and HICWA actually, was introduced by then Representative, current Senator Ron Wyden of Oregon, with the best of intention. He's a great guy, and like so many issues in this, the individuals involved have taken something that was meant to improve, to benefit, to help for the greater good of society, for the good of doctors, for the good of the public, and bastardized it through loopholes. They've twisted it, and they've redirected it for their own benefit.
Yes.
Now HICWA, that was introduced because who would volunteer for these peer review organizations, right, if they could be sued, if they could be, but like the illegitimate lab testing, like the PhD approved facilities, it's all done through these loopholes that people have. If we've learned anything from history, it's that people are going to exploit good intentions. There are always going to be people who exploit them, and that's what we're seeing here.
Yep. Well, it sure is, and it seems like a pretty bleak picture, right? And yet at the same time, what we've discovered in talking, as I said, with hundreds of physicians, is that yes, it is a very treacherous landscape, and the deck really does seem to be stacked. But there are some successes, and so Michael, could you comment on one of those successes that you can share?
Oh, sure. Well, first of all, the natural history of these types of the evolution of things such as this is it can take decades to rectify, to recognize, acknowledge. There's plenty of recent historical events with individuals and with organizations that we can see that.
Sure.
But here what we have is a system that has developed a number of, it's almost a perfect crime.
Yeah.
I mean, you could describe it as the perfect crime because they have layers and layers of protection that, first of all,
that is.
First of all, the lack of regulation, accountability, and oversight. First of all, that's the starting point.
Yes. Yeah.
But since that point, they have evolved into putting things in place that have removed the due process, and fundamental fairness for physicians, and protected themselves as far as opacity and culpability.
No, it's a major treacherous landscape. There's no doubt about it. But what I wanted to hear in the interest of time, Michael, is one of the success stories that you can share, and then I can share one, and then we can move forward here.
In the past year, this has evolved essentially since 1990. In the past 2 years, this has started to become on the radar, first in the medical community, now starting to be in the public domain.
Right.
But if you look at some of their loopholes, some of the chinks in their armor, there have been some successes in the past year.
Right.
I've dealt with some residents, some medical students, and a physician who was coerced into, they were coerced into these PHPs and have had successes.
And so you were able to advise them of the process and let people know, hey, wait a minute, let's back off here and help extract them from that machine.
Right.
Right. Well, and likewise, you know, I recall one of the physicians who had written into Medscape, and when he saw the comments, he had applied for licensure in a state, and then he was subjected to unnecessary testing. And before you know it, he said, oh my gosh, I'm in over my head already. I'm just simply trying to get licensure in a state. I have no complaints against me. I have a remote history of depression.
Right.
And I would say that because of the visibility that you speak about, it is specifically because of that he said, you know what, I'm not going to proceed with this thing here. I'm not going to go to that state. I'm going to back out of that.
Exactly.
Likewise, one of our colleagues put a lot of effort. It took over $100,000 in legal fees to extract a person who had been falsely accused of alcohol abuse on the basis of no criteria. It took $100,000 of legal effort to extract them from that. They were removed from the system, and that person said, I'm not going to practice in that state anymore, and left that state. So what we see is that, yes, there's some successes, but you know what? There's some real treacherous terrain there, and one has to know how to negotiate that. So, you know, there even with the successes, there are even larger caveats out there. So one of the caveats is the PHP blueprint. And what we know is that the PHP system has a larger program, and that is they're saying, oh, our model works. We know that it doesn't. But we also have strong reason to believe that the studies upon which their blueprint was based are in fact inherently flawed. But what we see about the PHP blueprint is basically all roads lead to PHP. And this is a major concern. The second thing that we've seen in terms of the caveats is that what's happening is that states are taking this term potentially impairing condition and letting that then be an entree to then intruding on a physician's life. Oh, you might have a potentially impairing condition. Well, you know what? A cold, a flu can be a potentially impairing condition when you get right down to it. The third thing that we see in terms of caveats is that it looks like burnouts are getting into the, PHPs are getting into the burnout arena. And we see things happening with regard to wanting to turn burnout into a major depression diagnosis. Now what happens is when you then have burnout as a depression and you're getting treatment for depression, then you end up having to report that to your medical board in violation of the ADA, by the way. And now you're susceptible again to getting referred to a PHP. So we see big potential problems here with PHPs and medical boards really circling around this notion of potentially impairing conditions. But then lastly, one of the biggest concerns that we have is that Michael has spoken with multiple medical students who are getting pulled into the PHP. They don't even have MDs yet, right? This is a physician health program, and they're getting referred to PHPs, and then they're having to defend themselves, right, Michael?
Exactly. And I just wanted to say one thing.
Yeah. Mm-hmm.
The PHP blueprint is not something that moniker was not applied to that later. It was applied to that at the initial publication of a very flawed,
yes,
methodologically, structurally. I mean, it's a very, very flawed study with insane conflicts of interest.
Yes, yes. And so that blueprint.
But it was deemed the blueprint at the offset.
Yes.
And the potentially impairing conditions, relapse without use, those are not medical terms. Those are pseudoscientific,
exactly.
Parapsychological. I mean, it's but in 2011, the Federation of State Medical Boards accepted them as valid entities.
Right. And that's a great concern. And that's the sort of thing that we're trying to study and advocate about. So in wrapping up here, we do have some thoughts about do's and don'ts both for physicians as well as for their attorneys. And this is based upon our own personal experience as well as the experience of hundreds of physicians and other healthcare providers around the country. Do's for docs. Number one, act with respect. Do not get into a stance of being defiant or brash. You are going to get into deeper trouble. You must exercise full restraint and decorum in dealing with boards and PHPs. It's important that you map out who's who and what's what, so that you really understand the terrain. You've got to document, document, and document. You save everything, you create a folder. You also journal everything, every interaction you have with someone in this sort of capacity. You're going to find that there are going to be phone conversations, or there might even be in-person conversations if an investigator is involved. And you want to go back and you want to date entry those and document what was said. It's very important that every physician take an active role in this process. Don't simply pass it off to an attorney and say, here, you take care of it. You need to be active. You need to get guidance from knowledgeable others. And so there are people, we have become a knowledge resource for many physicians. And so please feel free to tap into our knowledge. And we're gathering forces as we talk with more and more physicians. What's really important is to do a radically honest self-appraisal. If there is a real problem having to do with alcohol or substances or drugs, or having to do with depression, anxiety disorder, whatever, these are not disqualifying conditions, okay? These are illnesses and they're treatable illnesses. If there's a behavioral disorder, if there's a boundary violation, if there's, if you are disruptive, if you got a personality style that really is, pretty problematic, hey, look, this is the time to be radically honest, because if you're not radically honest and taking ownership of this, you are going to get derailed by this process. But what's also important to know that you have rights. Okay, you have rights under this system that must be honored. And so one of the most important pieces of advice that we have is find an independent appraisal, pay for it privately, and get that evaluation with somebody that you can trust, so that you get a real read on this thing before you end up going into the PHP process. Now, some don'ts. Here are some don'ts with regard to advice for docs. Don't automatically give this over to your attorney. Okay, everybody says lawyer up, and I think we're going to say, well, hold off on that until you study that landscape a bit. Now, of course, if there are some time deadlines, and this is one of the things that boards and PHPs do, is press these time deadlines. But if they're board deadlines, then yes, you need to pass that by so you can get some sort of a delay. But automatically deferring this to an attorney is not necessarily the wisest course, and we can share more with you about that later. Don't respond arrogantly and brashly. Don't commit to anything, don't sign anything unless you understand the full implications of it. We've seen physicians who have voluntarily inactivated their licenses. We've seen physicians who have signed a consent order, which prevents you from then bringing complaint and litigation against the board. We've seen people who are saying, I'm going to take a temporary leave from practice, or acknowledging, oh yes, I have severe depression, or oh yes, I am disruptive at times. Do not acknowledge anything, do not sign anything. And then here's the last one that's really quite a paradox. And that is, invest yourself fully in this, but don't get emotionally over-invested in it, okay? It is going to destroy you. It's going to consume you with a sense of anxiety and rage and sadness. And we, Michael and I, are very well aware of the impact of that. Here are a couple of advice pieces with regard to attorneys. And that is, attorneys have a tendency to take something and say, okay, I got it, and I'll call you when I need you. And then the physician ends up getting sidelined. Allow and encourage active, informed collaboration with your client, because they may know something about the system that you don't know and need to know. Recognize your limitations as an attorney. Just because you're an attorney, just because you're even in administrative law, does not necessarily mean that you know all of the nuances of medical administrative law. And in fact, what we're seeing is that from state to state, the regulations can change on a monthly basis, and tweaks can be made. One of the recent tweaks that happened was that the North Carolina legislature took away due process protection for physicians under a new law that was passed. So we want to also encourage attorneys to not overlook the procedural violations that occur in the adjudication process. These start to mount up, and by the time you end up getting to a hearing, you have so many procedural violations that the process is corrupted. And strive to get the entire process laid out clearly so everybody knows what the expectations are. If you find that you're dealing with an agency that's not willing to disclose the process, then there's something really amiss here. Some don'ts for attorneys. Don't automatically rely on due process. I understand that attorneys really trust the legal system and say, oh my gosh, the legal system is, like it's inherently beautiful. It's refined over time. Well, the law may be defective and the process may be defective. Don't treat your client situation as a compromise. Well, they said this and you said that, so we're going to go somewhere in the middle. No. That's an unhealthy compromise. And your physician may, in fact, be 110% correct in their assertions. Don't treat this with a criminal defense mindset, as though you're entering into a plea deal or some sort of a bargain. Well, we'll trade you for this or that. That this is not a criminal proceeding. This is an administrative proceeding. And to say it's an administrative proceeding does not lessen it. As a matter of fact, it could be life-threatening. And don't wait for the administrative hearing as though somehow fairness is finally going to emerge in that hearing. We have every reason to believe that a number of these hearings are not undertaken with due process. So in wrapping up here, in the interest of time, we know we covered a lot of territory, but we wanted to basically lay out the landscape for you. Very few people really, I would say, Michael, even us, none of us really understand the full picture. It's that complicated. Very few people really get to see the larger landscape, but Michael and I and our colleagues, some of us have been at this for close to 10 years studying this nightmare here. It's important to understand that missteps in this process are just like walking into a minefield. And when you step on a mine, it damages and damages permanently. So the missteps can be made, and as Michael referred to earlier, once you go down one of these chutes, once you go down one pathway, your options become incredibly restricted. Once you go to the 4-day evaluation that you thought was going to be fair, and it turns out it's a rigged deal, you've now got another set of diagnoses on your hands that are working against you. So be very cognizant of the choices that you're making. Recognize that you don't have to go this alone, okay? There are others who have, in fact, charted this territory and who want to help other physicians and other healthcare providers. And, in fact, you shouldn't try to handle this on your own. These are major happenings. They require the utmost care and utmost diligence as you lay out the program about how you're going to proceed to this inquiry. There's knowledgeable guidance. And there are some strategies that can be used to help negotiate your way through this landscape here. So I recognize that we are really pressed on time here, and we promised everybody that we'd be as compressed as possible. We can't cover the entire territory, but it's so great that you guys have attended. Michael, closing comments, a final observation that you'd like to share with the group.
Well, I think in closing, I'd like to say that what we have here is a self-appointed authority that has bamboozled other authorities. They are illegitimate authority, and they are a rational authority. And it is important that we as individuals and collectively get them in the crosshairs, target the bad policy,
yes,
and fire.
Yes. Thank you so much. Yep. Thank you. Well, we have a whole host of comments there that are coming in, and we are, as I said, we are not able to entertain comments and questions due to the time. It's pretty likely that Michael and I are going to be offering subsequent specialized webinars. But take note here of our emails, and you will be getting these on the handout that we're going to be sending to all participants, as well as some of the recap of the slides. Michael's is there, mine is there. We have a shared phone number that we've established to receive your calls. And Michael and I have discussed setting up half-hour phone conversations with any person who would like to sound out their case with us confidentially, and there's utterly no obligation to pursue any sort of a consultation arrangement or a coaching program, although we do offer those services. And here's the link for it. It will take you directly to the scheduling page. As you'll see, it's a bit.ly link, and it's http://bit.ly/free, F-R-E-E, PPLL call. Okay, that's Perilous Physician Licensing Landscape Call. And that link on the handout is going to take you directly to the scheduling apparatus. So everyone, thank you so much for joining us tonight. And it has been a delight presenting to you. Wish you all well. We look forward to being of help to you. Thank you so much, Michael. Thank you so much, Michael. All right. Good night now.